Hey, my name is Robbie Crosier. I'm an M&A attorney and an adjunct professor of law at Texas A&M Law School, and today I'm going to talk about holdbacks. So, in an M&A transaction, you may have heard a term called holdback that refers to a certain amount of money that will be held back from the purchase price that would otherwise be paid out to a seller. So the way that that looks in practice is if you're buying a business for $1 million, let's say you're purchasing a plumbing company, um, and this is going to be an all cash payment of $1 million, just for example. Instead of cutting a check for $1 million or wiring $1 million directly to the seller on the closing date, you would instead wire, let's say, $800,000, and you would keep $200,000 apart from the proceeds of that sale. That $200,000 holdback, instead of going to the seller, would go into typically a third-party escrow account. That's an account that's managed by a neutral third party. Typically, there are law offices that do this. Sometimes banks do this. Other financial institutions, they will act as essentially like a trustee of that money, and they'll hold it in an escrow. There will be certain conditions upon which they are instructed by the buyer and seller. These conditions would be mutually agreed to beforehand. They would be in the purchase contract to say, hey, escrow agent, escrow officer, you only release the funds, this in this case $200,000 holdback, to the seller upon the meeting of these conditions. And those conditions can be a handful of different things. One such condition might be, let's say this holdback could be in place because the buyer wants to make sure that a really critical customer of the seller remains a customer post-transition, and typically for a period of some number of months, let's say 6 months. The holdback clause in the purchase document may say this $200,000 will only be released after 6 months, so long as that customer is still a customer of the business. And that's just meant to be a mechanism to protect the new buyer, because the seller has promised them, hey, we're 100% sure that this prime customer is going to stay on. Another purpose of holdbacks is to account for any kind of breach in the reps and warranties or representations and warranties found in the purchase agreement. Reps and warranties are promises made by the buyer and seller. Typically, the ones made by the seller are the most important. And these reps and warranties on the seller side will be things like, hey, we promise that on the fundamental side, we promise that we have the right to sell you this business. We have right title to all the assets in the business. Other things that are typically categorized as non-fundamental reps and warranties but are still very important are things like, hey, we've given you financials, we've given you a P&L, we've given you tax returns. All of those financials are accurate. We've given you a list of inventory. All that inventory is accurate. Any kind of discrepancy between information that was presented to the buyer in the form of promised reps and warranties, any kind of discrepancy between what was promised and what is found out to really exist after the sale, those would all be covered in the reps and warranties. And that amount, typically the holdback is a mechanism by which that discrepancy can be collected on. So if there is some kind of technically a breach of the agreement because the reps and warranties were inaccurate and it would damage the buyer in some amount, let's say it damages them in the amount of $100,000, the buyer, if the contract has been drafted in such a way that this is accounted for, the buyer would have the ability to go to the escrow officer and say, hey, there's been a breach of the reps and warranties, and we are entitled to retain $100,000 of that total $200,000 holdback. So you can release the other $100,000 to the seller, but you better send $100,000 back to us. There is going to be a time limit placed on this, so typically it's going to be common for reps and warranties, holdback, to only last for a certain amount of time. That may be 6 months, 12 months, 24 months, depending on what the parties agree upon, and depending on which conditions this holdback are meant to account for. So that's a quick primer on kind of what a holdback is. Last little piece of that is this holdback can be anywhere. It could be any amount, but it's common within Main Street and lower middle market deals for it to be somewhere in the 10 to 20% of the purchase price range. So that's going to be fairly common for you to look at. This amount is entirely negotiable and is often heavily negotiated by the parties. So something to keep in mind during your next business acquisition.